Counsel, is there any legal cause why judgment can't be entered?
No, Your Honor.
Noted.
Mr. Ehlinger, based upon the verdict returned by the jury finding you guilty of the felony offense of rape, I'm going to find that you are guilty of that offense, and I will impose a judgment of conviction. There's been a fair amount of discussion this afternoon about the two bill factors in Idaho Code 19-2521, which describes guidance for the court in arriving at a sentence in a particular case. The opening paragraphs of that statute talk about the policy of the state towards sentencing and requiring consideration first of a sentence that avoids imprisonment. There is other case law that suggests that courts should arrive at a sentence with the minimum amount of incarceration to achieve the objectives of sentencing. But the factors that are set forth under the provision, which essentially also describe what has been referred to by counsel as the two bill factors, the individual factors of the statute that weigh in favor of avoiding a sentence of imprisonment talk about whether or not conduct caused or threatened harm, whether there were any grounds that excused or justified the criminal conduct, whether the victim in any way facilitated or induced the commission of the crime, whether the defendant is compensated or will compensate the victim, whether the defendant has a history of prior delinquency, whether the circumstances are unlikely to occur, and whether the character of the defendant is such that it would support avoiding a sentence of imprisonment, and finally, whether or not the defendant demonstrates amenability to treatment. I have reviewed the pre-sentence investigation, the psychosexual evaluation. I have reviewed the testimony and the transcript that you provided, and I've considered the statements that you made today, and all the other factors, or all of those factors, it seems to me, don't support a sentence that avoids imprisonment. I will acknowledge that the factor with respect to character, there were 26 letters of support. Most of those who wrote those letters attested to their own impressions of you as being courteous, kind, helpful. Those are the things that informed their opinions. Those are also consistent, those descriptions are also consistent, it seems to me, with what Dr. Johnstone relied on when evaluating the results of the MMPI-2 and the personal assessment inventory that led him to the conclusion that you were not amenable, you had very low amenability for treatment. Once I've considered those factors, those that might support avoiding a sentence of imprisonment, then I'm informed to consider the factors that weigh in favor of a sentence of imprisonment. Whether there's undue risk that you'll commit another crime that's harmful to another person, whether or not a lesser sentence will appreciate the seriousness of the crime, whether or not it will provide appropriate punishment and deterrence to you and deterrence to the community in general, whether or not you're a professional criminal or a multiple offender. As I thought about those, and I thought about Dr. Johnstone's assessment of your risk classification, and I agree with the state that he arrived at that risk classification as moderate based upon the assumption that you would be amenable to treatment, that you would benefit by that. as I've listened to you and I've read the statements in the pre-sentence investigation, I have to come to the conclusion that your denial, your demonstrated lack of empathy for the victim, your propensity to blame the victim. As I listened to you today, I wrote down two words: victim and hero. That you see yourself as a victim and you see yourself as a hero. And frankly, I don't see you as either one of those things. You created your own circumstances to put you here today. I understand that your testimony under oath didn't draw into question whether there was penetration, whether there was consent. And it clearly didn't dispute your own acts in bringing yourself to completion in a way that sort of unbelievably disrespected and denigrated the victim in this case. Your description of how those things happened and your failure to acknowledge or explain the injury that she received in the back of her head trying to resist your efforts stands in stark contrast to your claim that everything was okay. When I consider those things, I can't find that rehabilitation is a realistic objective of sentencing. When I think about those things, you're all amenable to treatment. With respect to the potential to appreciate the seriousness of the crime, you stand convicted of forcible rape. That, in and of itself, seems to me to require a significant sentence so as not to appreciate the seriousness of the offense. With respect to punishment, I am persuaded that there were vast differences between you and the victim in this case. Differences in your age, your size, the cultural power that you each possessed. And I am persuaded that you used those things and manipulated them to your advantage in the completion of this crime. It is unclear to me, given the relatively unique circumstances and relationships in this case, whether or not general deterrence can realistically be achieved. It is clear to me, however, that an appropriate sentence will specifically deter you, at least through the period of incarceration. Well, I can't come to the conclusion that you are a multiple offender. You clearly have a criminal record. And as I reviewed the police reports and your explanation of how those offenses occurred and your roles in them, I had to note that you have a pattern of explaining, excusing, deflecting, and blaming others for the circumstances you find yourself in. That factor doesn't mitigate in favor of the sentence or the imprisonment. I've thought about the pre-sentence investigation's recommendation to retain jurisdiction, and I have come to the conclusion that I am completely unclear of what the basis for that recommendation is. The retained jurisdiction program is fundamentally a period of time for treatment and evaluation. And given the attitudes that you have projected in this case, it appears to me that that is not a practical recommendation at this time, that you are not ready at this point to engage in treatment. In considering all the factors informing my decision, recognizing my obligation to make a discretionary decision based on reason, I concluded that the appropriate sentence in this case is a unified term of 20 years, consisting of a minimum term of confinement of 8 years fixed, followed by an indeterminate period of 12 years. I won't impose a fine. I will order that you pay court costs and a civil penalty in the amount of $5,000 in favor of the victim in this case. Additionally, I'm going to order that you pay restitution $2,015.39 and require that once released from incarceration that you comply with the requirements to register as a sex offender as set forth in Title 18, Chapter 83 of the Idaho Code. At this time, you are remanded to the custody of the sheriff to be delivered to the Department of Corrections for execution of sentence. There is no bail to exonerate. You'll be given credit for 139 days served prior to the entry of this judgment. That is the court's judgment. Mr. Van Ehlinger, you have the right to appeal this judgment. 42 days in which to take the appeal from the date the judgment is made and entered. You have the right to be represented by an attorney in pursuing that appeal. If you can't afford an attorney, one will be appointed for your public expense, and also the payment of costs will be public expense. Anything else we need to talk about?
Your Honor, were you entering the no?
I will enter the no contact order. Thank you for reminding me. The order will be in effect until August 30th of 2055. I'm intentionally making it 10 years beyond the expiration of the term of confinement. Anything else?
No, Your Honor.
Not from the defense. Thank you. We will be in recess.
All right.